This is James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, Ms. Brady, Mr. King, Ms. Higgs, Ms. Spengler, and Ms. Nelson. And the people are represented by Mr. Brockler, Mr. Orman, Ms. Pearson, Ms. Stitch McGuire, Mr. Edson, and Mr. Edwards. We are outside the presence of the jury. A couple of things. First, with respect to juror number 118, as you know, she sent a second note earlier today indicating that she was okay with us not delaying things for her son's graduation and asking us to just proceed. I feel like I didn't get a chance to complete the discussion with her because I told her when she was in here that I would try to look at the emails and follow up, and then it's at that point that she sent us the note. I simply wanted to tell her that I appreciate her willingness to do that and leave it at that and not have any further discussions. Are the people okay with that?
Yes, Your Honor.
Is the defense okay with that? Okay, we'll plan to do that. So we'll bring juror number 118 first. The second thing has to do with the people's intent to call two witnesses with respect to Veronica Mosher Sullivan. And I said I would think about it over the lunch break, and I did. And I'm going to allow the people to do that for the following reasons. Number one, I do think these two witnesses have different things to say about Veronica Mosher Sullivan. And of course, the people are aware of my order that says I'm not going to allow any testimony that just repeats what someone else has testified to. So that's going to apply, and if the defense at any point believes that that rule is being violated, an objection should be made, and then I will rule on the objection. Number two, I based on the testimony that has been presented yesterday and today, I am not concerned, at least at this point, with the jury being overwhelmed with emotion. And that's what the law is always concerned with when it comes to victim impact testimony. The testimony that has been presented related to victim impact has been at times very emotional, but I've been watching the jury, and there was one point yesterday when I think we had a handful of jurors who appeared to be crying. They were emotional. And when I say crying, I don't mean bawling or anything like that. They were teary-eyed. They were crying, not excessively so. Only a couple of those jurors are deliberating jurors. There have been other times between yesterday and today when a couple of jurors, those couple of jurors are included within the handful, when they have become emotional at different points yesterday and today on a few different occasions. Only one of those is a deliberating juror as far as I've been able to see. Number three, the third reason is that I indicated before the victim impact evidence was introduced that the people had to show self-restraint. And for the most part, I believe they've done that. There have been things that were included in the disclosures that the people did not go into and did not elicit, things that were included in P83, I think it was, P83 and P83D, I think we ended up labeling it. There were things in those detailed disclosures that had the potential to be very dramatic and emotional, and the people did not elicit that testimony, even though they could have done so. So that's number three. And number four, I've been giving the jurors a cautionary instruction throughout the presentation of victim impact evidence, and I am confident that the jury will follow that instruction. The instruction tells the jury or reminds the jury that it may not be swayed by emotion, that its decisions in the sentencing hearing may not be the result of any irrational or arbitrary emotional response, and that each of the final sentencing verdicts has to reflect each juror's individual reasoned moral judgment. So for all those reasons, I'm going to allow the people to call two witnesses with respect to Veronica Mosher Sullivan. I'm not concerned that the jury is somehow going to infer from this that Veronica Mosher Sullivan is a more important victim than other victims, or that her death is more significant than the deaths of other victims. I think it's going to be clear, based on what representations that people have made, that the reason that they're calling two different witnesses is because the grandfather was present at this, was it a kindergarten event?
Yes, sir.
Continuation ceremony. And mom couldn't be there because she was at a funeral. So it'll become clear to them that that's why the grandfather is here to testify about that particular event. But otherwise, Veronica's mother will be testifying, and that's Ashley Mosher. So I'm not concerned that the jury is somehow going to read something different into it. And the fact that the people are only calling two witnesses with respect to one victim also helps me arrive at this decision. Yesterday, and even before yesterday, what the people were talking about was calling perhaps two witnesses with respect to four victims. And I indicated that I was going to wait until, or I wanted to wait until at least one witness had testified with respect to each victim, and then go from there and see at that point whether I felt that it was appropriate to allow additional witnesses with respect to any victim. So now they're saying, Judge, we're only going to do it with respect to one victim, and they have provided the court a reason as to that, and that is that the grandfather was the only one who could be there, be at the continuation ceremony. Mother could not be there, and then of course grandfathers from the other side of the family as well, which the people indicated in the offer of proof that they made earlier today, or the explanation that they provided. So the next thing I wanted to talk about, I became aware during the lunch break that apparently there's been another shooting in a theater, and I don't know whether the parties have become aware of that or not, and I believe it was in Tennessee. I don't know all the details, but the question is, do the parties want me to provide any additional admonishment to the jurors as a result of it? I'm already telling them that they can't learn anything about this case or any case like it, and I've already told them that they cannot learn any information from media or news reports with respect to the event in Louisiana. And of course, we all know that the event in Louisiana that I'm referring to is the theater shooting in Louisiana. But what I've been telling them is the event in Louisiana, and I've done that at the attorney's request, which I think is appropriate. Mr. Orman, do the people have a position on that?
Your Honor,
I was going to bring that up, and I appreciate the court doing that. What I've been able to learn from news reports, which are early and therefore possibly inaccurate, is that it was in a theater. Apparently, the person who is dead was the person who committed the crime. Apparently, this person entered the theater with a hatchet and a gun of some sort. And what I was reading is that apparently the person attacked some people in the projection room of the theater, who I assume would be theater employees, and that 3 people were treated by the fire department for exposure to pepper spray. Unknown whether that was something that the attacker was using, or one of those 3 people was using, or someone else was using in self-defense. And one of them apparently had some type of wound that could have been a hatchet wound, and that the police were called, and that a police officer entered the theater and apparently got in an exchange of fire with this person, and then took cover and fled. or went outside, and then the SWAT team shortly arrived and got in a fire exchange with this person, and that person was found dead, unknown if they killed themselves or were shot by the police. It does not seem to be, so it could just be a crime that happened in a movie theater, not because of the movie that was being played or anything like that. I don't know. It's preliminary reports at this point. If the defense wants the court to inquire or say something not to read about this, obviously I don't object, but it seems like a pretty different type of crime than we're talking about here.
All right, and for the record will reflect that it's the beginning of the afternoon, and so this apparently hit the news over the lunch hour, and so it's not an overnight situation, which would be more concerning. It's a just a lunch hour situation when at least the story started making its way in the news, and so I thought I would bring it up and ask if either party had a position on it. Ms. Brady, do you have any position on this?
Judge, our position is perhaps if the court, when it does give the admonition at the end, to emphasize not to, as you've been doing, but maybe especially emphasize or any case like this, and perhaps even tell them, you know, we are really close to the end of this case, and perhaps it's advisable to avoid the news as much as possible in general until you get this case, so that you don't inadvertently get exposed to information from the outside. I think that would take care of it. I hate to have the court emphasize yet another incident, which I think will tip them off that there was another incident at a theater. And so I think if the court just emphasizes no cases like this and perhaps avoid news as much as possible, and hopefully that'll do it.
Okay. That's what I was inclined to do, and I think that's the best approach, and so that's what I'm going to do. I'm going to go through the advisements at the end of the day today, and I'm going to try to emphasize the part about not only this case, but any case like this case, and then request that if at all possible they not watch or listen to or read any news at all. So, all right, is there anything else before I bring in juror number 118, just to say that we appreciate her willingness to work with us in terms of our schedule?
No, sir.
Anything in from the defense?
I also thought maybe if the court could again remind the jury that if they do overhear something or see something inadvertently, to make sure and let the court know.
I will do that.
Thank you.
Let's bring in juror number 118, please. The record should reflect that juror number 118 is now present in the courtroom. Good afternoon.
Good afternoon.
I just brought you in to say thank you and to tell you how much we appreciate your willingness to work with us in terms of our schedule. I very much appreciate that. I read your last note, and your last note indicated that we could proceed, and I just wanted to say thank you for that.
The first note was just to ask you if you knew. I didn't want anything changed.
Okay.
I didn't need any suppositions. I just wanted to know if you knew.
And you know what? Looking or remembering now back at the note you sent, you're right. That was your specific question. Your specific question is, do you know what the schedule is? And so, but I figured that you were interested in that because you were trying to figure out whether to make that trip or not. But
Correct.
Nevertheless, my appreciation and the appreciation of the parties remains the same. We very much thank you for your willingness to do that.
You're welcome.
Thank you. Okay, let's bring the jury in, please. Please be seated, everyone. The record should reflect that the jury is back in the courtroom. Welcome back, folks. I hope you had a good lunch. Good. All right, the people may call their next witness at this time.
Thank you, Your Honor. The people call Robert Sullivan to the stand.
Good afternoon. Do you solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? I do. Please be seated. Could you please tell us your full name and spell your first, middle, and last names?
Robert, excuse me, let me pour a little water. It's Robert Mitchell Sullivan, R-O-B-E-R-T, M-I-T-C-H-E-L-L-S-U-L-L-I-V-A-N.
Mr. Brockler, you may proceed.
Thank you, Your Honor. Sir, to you, who is Veronica Mosier Sullivan?
She is my granddaughter, was my only granddaughter, only grandchild.
Tell us how you are related to her.
My son Ian was married to Ashley, and they had Veronica in 2006. And as I say, she was our only grandchild. Ian is our only child, so we lost our only child's only child.
Sir, at some point after the birth of Veronica, your son and Veronica's mother, Ashley, divorced. Is that fair?
Correct.
I want you to, if you could, describe for us the relationship that you were able to build with Veronica leading up to some things that we're going to talk about here.
Okay, well, when they were married, of course they had Veronica before they were married. They got married when she was 3. And, you establish the relationship as soon as she was born. And, the thoughts, the memories of each phase. I remember with Ian, when he was a child, when he was born, and being present and carrying him, being the first one to hold him. And I remember feeling like I was floating. It was such a wonderful experience. Well, raising him, each phase of his life, quite well remember the good and the bad times, the things that everybody has as a child growing up. As a parent, you learn, and becoming a grandparent is a special distinction there. So, we were able to incorporate some of the things we learned with Ian, raising him, and to enjoy. As a grandparent, you're limited in your exposure to a child, to your grandchild, and you tend to focus on, the fun things, the enjoyable things. You try to engender certain qualities and experiences you want them to experience. And, there's so many memories I have as far as, interacting with her, knowing what you can do as an infant, as a toddler, as a small child. And, I couldn't wait, to do some of the fun things. I wanted to interject the silly, the fun, goofy things that, make up a child's life before life gets more serious.
Tell us about in the months or even the year leading up to May, June, July of 2012, how much did you get to spend time with Veronica? How much time did you spend with her?
It was limited 2 weekends. My son had Veronica on the weekends because of Ashley had custody after the divorce, and so it was limited. But within those limitations, we certainly enjoyed her to the fullest. You know, having a grandchild, it's, like I said, it's such a wonderful experience. What you can share with them, as I say, you know, what you want to engender, what you can put into their lives, and what you've learned already after raising a child. So the things, the experiences we had, you know, going to the zoo, going hiking, Ian took her camping, taught her to ski, well, as much as you can to that extent, you know, that he had her up at the slope where he was working at Winter Park. But sledding, the experiences that you get to share, things you want to expose them to, books, reading, you know, stories that are focused for them, movies, animated movies, things that, you know, are appropriate for that age. And, you know, I think of her, and there's certain aspects. I know later we will get to the photo that I wanted to, you know, mention as far as the significance of the photo and the qualities that I saw in Veronica. There was just a sweet innocence about this child. She had a sensitivity about her that, you know, I could relate to. When I was a kid, I was very shy and very sensitive, and I saw that in Veronica. She had, of course, the characteristics that most all children do, very playful, and it was those aspects I wanted to reinforce. In playing with her, I would really enjoy picking her up, running around pick her up like a sack of potatoes, like I said, and playing like a gorilla man, monkey man. And she would giggle and shriek with delight. And she really loved that game. But the other things, just acting silly, you know, it's like sometimes when I would see her, it'd be maybe several weeks. And especially when the period came after a long absence where I didn't get to see her, she was a little timid, and I'd look at her in the eyes and, you know, just start making facial, you know, caricatures and just funny faces to get her to lighten up. And she would giggle and start to laugh, and, you know, those type of things. I think they're essential. I think they're essential in building a person. You know, humor, you need some levity. You could use levity in this courtroom a number of times, I know, and humor is an essential part of life.
Sir, in the time that you had with Veronica, did you try to preserve a lot of that through pictures and video and stuff?
Yes, unfortunately, the burglary in October.
Would anyone object? 401, 403?
Would counsel approach, please?
Sir, we were talking about pictures and video, and we have some here that I want to take up to you, if I could. Your Honor, may I approach the witness?
Yes.
And I've shown these to counsel. Sir, I'm handing you what's been marked as People's Exhibit 4730, 4732, and a disc that is 1099. Take a look at those, and just tell us first off if you recognize what they are.
Yes, I do.
We'll get to publishing those in a bit, but first off, there's a picture that is, I think it ends in 32, sir. Forgive me, I didn't write it down in there. 4732. Do you see that one?
Yes.
Tell us what that is a picture of.
It's a picture of Veronica, my granddaughter, taken inside our house in our office.
And do you know about, in her age, where that is in relation to the other things we'll discuss, Christmas and her continuation?
I'd say she's about 6. This was taken, I'd have to look back at the file and see, but I know it was either taken in the fall of 2011 or spring of 2012.
Is that a fair and accurate picture of what she looked like before she was shot to death?
Oh, yes.
Your Honor, I'd move for the admission of People's Exhibit 4732 into evidence.
Is there any objection?
Nothing further?
All right, based on my prior rulings, P-TR-4732 is admitted and may be published.
Ma'am. You remember what occasioned that, or was this just one of many grandpa pictures?
This is just one of many. One of the few that still have.
As we get into these next pictures, you've alluded to it to some extent, but tell us, in your contact with Veronica, what was her personality like?
Well, as I was saying, the thing that struck me about her first and foremost was her sensitivity. A little timid, but very bright, very smart, and a very fun-loving child. As I say, 6 years old. There's only 6 years there, but you can see the seeds of, great potential. And she was a sweetheart. I mean, when I think of her, the images I see in my mind, sometimes they correspond with some of the photos, and several photos that you have not submitted here. But I think of an angelic little girl. To me, she personified a little angel. I know people and most parents will feel this about their children. Your parents might have felt this way about you. Little angel. I don't use those references as much. But in her case, this was in actuality. It was true.
Take a look at Exhibit 1099, sir. That's that disc.
Okay.
Tell us if you recognize the disc and tell us what's on it.
Okay, on this disc, there are fragments of her last Christmas. She spent Christmas with us, and we had quite a elaborate Christmas celebration. When I shot the video, I'd done this for years, to the point where, my son, my wife was like, oh my God, here we go again. We get out the camcorder and basically, recorded the entire Christmas morning. Well, on this disc are fragments of that. The whole process lasted well over an hour and a half. And my son, as well as my wife, Veronica's grandmother, and myself, really indulged Veronica. And you only get to see fragments of that. As I was told, they couldn't play the other parts because of the music.
Hold on,
That's
sir.
okay.
Just answer the questions, okay?
That's okay, sir. In terms of that disc, do do we get a better sense of Veronica's personality and how she interacted with you and that part of the family?
You'll see little bits of it, not as much as I would like to see, because to truly convey it.
All right.
I understand.
That's stricken, and the jury will disregard it. Do you want to play the video, Mr. Brockler?
Yes, sir.
1099?
Yes, sir.
Let's go ahead and do that. The jury will disregard that last sentence and will treat it as though it never heard it. Thank you.
Your Honor, forgive me. I don't know that I've moved to admit it yet, but if we could do that first, move to admit people's 1099 in evidence.
Nothing further?
Pursuant to my ruling, it is admitted.
Can you publish that for us, ma'am?
Okay. You want to turn on your stereo?
Yeah.
Then you can play music, although I think I ought to play it a little more traditional. Okay. You want to? You can go ahead and open your stocking.
Just let it be. Play. Yeah. I'm just gonna play it. You haven't even heard the whole thing yet.
Don't eat this. This is so bad for her.
Yes, it's not good for dogs at all.
Ooh, a happy banana, kind of like a rainbow.
Santa must know what you like, huh?
Oh, pizza. Robin.
Oh.
A robin.
Or a woodpecker. Look at his red head.
Blue jay.
A blue jay.
Oh my God.
All right. Hold on.
What? Santa got her that? It has tape on it.
Yeah. Need help?
These are the things you have to think about when you wrap them. But just as necessary.
Yeah. That's what I thought.
Yes.
Oh, you noticed the pretty bow again.
No.
Where's the hat? Santa hat? But Ruffy.
Pretty ribbons,
Did you hear
huh?
her? Pretty bow. She noticed.
See? My little
Yeah.
minuscule. It's full food.
I didn't get that.
Yeah, you like it?
Yeah.
Thank you. Thank you.
Yeah.
Oh, look, Santa still brought me some gifts.
Mr. Brockler?
Your Honor, can we approach, please?
Yes. Brockler, you may proceed.
Sir, I want to fast forward to May 25th, 2012. Do you recall that day?
Yes, I do.
Now, you, on May 25th, 2012, you ended up attending a continuation ceremony for Veronica as she was making the transition out of kindergarten. Is that correct?
Yes.
Now, when you were there, was in part the reason that you were there was because her own mother couldn't be there for it.
Correct.
And did you again bring your camera with you?
I took a little pocket camera with me, not the normal one I use.
When you went to the continuation ceremony and you went inside, Veronica didn't see you right away?
No, she didn't.
Did she seem to you to be looking around for any sort of family that she could find?
Yeah, her eyes, she was surrounded by a lot of children, and she was looking around, but the area, the audience where the families were, she didn't see any faces she recognized.
You were able to capture with that pocket camera that first recognition that family was there at that ceremony. Is that right?
That's correct.
Your Honor, could we have, with the court's permission, previously admitted 4731 published?
Yes, you may.
Is this that picture, sir?
Yes, it is.
Thank you. Later in that day, after this continuation ceremony, you took her out to get ice cream.
Yes.
Did you at that time have your bigger, better camera?
No. Throughout the day, I just had the little pocket camera, but I took the photos that I submitted, the one at the ice cream shop.
Now this one, and forgive me, 4730, take a look at that down there. Is that the one we're about to talk about?
Yes.
Is that the picture you took after the continuation ceremony on May the 25th, 2012?
Yes, it is. We took her there to celebrate.
This captures a little bit more of sort of her personality on that day?
Yes.
Your
Yes.
Honor, with the court's permission, I'd like to move to admit 4730 into evidence.
Any objection?
Nothing further.
All right. Based on my previous rulings, P-TR-4730 is admitted and may be published.
Ma'am, can we see 4730, please? Is this that picture of her wearing that same outfit from that other photograph?
Yes.
Thank you, ma'am. I don't have anything further, Your Honor.
All right. Do you have any questions?
I don't, thank you.
All right. And the jury does not appear to have any questions. May Mr. Sullivan be released from his subpoena?
Yes, sir.
Any objection?
No, sir.
All right, sir. Thank you. Call your next witness, please.
Your Honor, the people call Ashley Mosier to the stand.
Good afternoon. Could I have you raise your right hand, please, so that I can administer a note? Do you solemnly swear or affirm under penalty of law that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Could you please tell us your full name and spell your first, middle, and last name? And I know you've testified before, but if you would remind us, please.
Ashley Veronica Moser, AShleyVeronica
All right. Could you move the microphone closer to her, please, or could you move it close?
Ma'am, do you need my help to move that, or do you have it? I know you're soft-spoken, and forgive me for asking you to talk right in there, but it's the only way we're going to hear, okay?
Okay.
All right, Mr. Brockler, you may proceed.
Thank you, Your Honor. Ma'am, have you been in the courtroom here as we've put up some pictures of Veronica?
Yes.
Is that your daughter?
Yes.
I know that we had you in here before testifying about what happened to you in the theater. That's not what we're here to talk about right now, okay?
Okay.
I want to talk to you about your daughter, who she was to you, and then we'll talk about the impact of her murder on you, okay?
Okay.
When was Veronica born?
December 23rd, 2005.
How old were you when you had her?
18.
Were you single?
No.
Were you married?
No.
Were you with Ian?
Yes.
Did you get married after her birth at some point?
Yes.
How did you come up with the name for her?
Actually, Ian really liked the name Veronica, so he chose that name, and I chose her middle name.
What's her middle name?
Hani.
Spell that for us.
Hanni.
Where'd you get that?
When I was pregnant with her, I worked at Starbucks, and I had a regular, this older gentleman, and every day he would bring me 5 girl names, and one day I just fell in love with the name Hani, and he said it was, I don't know, a Swedish name, but so that's how I got that name.
I know she was 6 when she died, but what was her personality like?
Her personality was, she was, like, very, like, silly and fun and excited and happy and just fun-loving and caring and sweet.
Did she have any brothers or sisters?
No.
What were some things leading up to July? What were some things that she liked?
She liked to draw and she liked to read.
She a good reader?
Yeah, she was.
What kind of books did she read?
Oh, just like well, she had just learned how to read, so I don't know, the little ones that they send home from the school, like the 3-letter word ones. But I mean, I would read to her at night, so.
Did she have friends that she played with?
At school, yes, yeah.
Did you see her interact with her friends?
Yes.
What was she like as a friend in her 5-year, 6-year?
She was a follower, but she was just, I don't know, caring. I mean, she was not a bully or at all. She was just very submissive, I guess. Wanted to, follow whatever the other child wanted to do.
I'm going to use a word, demeanor, but I want to ask you, was she upbeat, subdued, sad, happy? How was she in her day-to-day interactions?
She was very upbeat and very happy all the time.
What other things did she like? Did she like toys?
No, not really. She didn't like toys too much.
What did she prefer to toys?
Mostly coloring and looking at books, and she had a lot of energy, so just like going to the park and stuff.
Before July 20th of 2012, did she like movies?
Yes, she did.
What was she like when she'd watch a movie?
It was very unique. When I would put on a movie for her, if you would try to talk to her, she couldn't even hear you at all. and I'd have to like go up in front of the TV or like turn it off for her to um, hear me at all.
Did you see her interact with your mom and your other relatives?
Yes.
How was she with them?
She was good with them. I don't know, like
Nice.
nice, yeah.
She a hugger, a cuddler, handshaker, high fiver?
No, she was very independent, I'd say. She wasn't like too much of a hugger. Only when she was tired. That's when I knew when she got tired.
What was your relationship with your daughter like leading up to July of 2012?
She was like my best friend. She was my life.
I was going to ask you that. How much of your life from the age of 18 until July of 2012 did your daughter consume?
Like all of it. I didn't go more than 24 hours without her.
Was there something that you did together that was a favorite thing of yours?
Well, my favorite thing was just finding free festivals to always go to. Free days at the zoo, the museum, just going places.
Did she enjoy people?
Yeah, was very social.
I think you've described her in the past as she loved everybody.
Yes. She did.
Was she excited?
Very.
20th, 2012, was she excited?
Oh yeah, she was very excited, especially just because she got to hang out with, the older girls, so.
And you had told her before the theater about your good news?
Yes. Yeah, I did.
Was she excited about the prospect of being a big sister?
Yeah, I think, yeah, she was. I don't know how well she grasped it, but yeah.
We've heard about what happened in the theater and how you came to find out about your daughter's death.
I'm sorry?
We've already come to find out about how you found out about your daughter's death and what took place in the theater. I want to ask you about afterwards. Without going into the physical stuff, the stuff we see that we know about. There's no easier question than how are you different after the murder of your daughter?
Very different. Just deal a lot with depression and anxiety.
Tell us more about that.
I don't know who I am anymore. 'Cause I was a mom when I was 18. And that's all I knew how to be. And now I'm not a mom. So.
Do you have to take medication?
Yes.
Not for the physical stuff, but for the emotional stuff?
Yeah.
Tell us how your daughter's death has caused you to have to do this.
Yeah, it has caused me to be in an intensive outpatient program at a depression center. Because there was times that I did not leave the house. I didn't want to do anything.
Are you on medications right now?
Yeah.
Do they help you get through the day?
I mean, well, yeah, sometimes.
What's the thing you miss most about your daughter?
I don't know, everything. Her. Her smile, her laugh. The way she just was, she was my little silly Billy. I don't know, she was always trying to make people happy.
Thank you, Your Honor. Nothing.
Do you have any questions, Ms. Brady?
No, sir.
And the jury does not appear to have any questions. May Ms. Mosher be released from her subpoena?
Yes, sir.
Is there any objection?
No, sir.
All right, Ms. Mosher, thank you. Members of the jury, it's 3 o'clock, so we're going to go ahead and take our afternoon break right now. I want to remind you folks that you may not be swayed by emotion. Your decisions in this sentencing hearing may not be the result of irrational or arbitrary emotional response. Rather, each of your final sentencing verdicts must reflect your individual reasoned moral judgment. Does everyone understand that? And everyone's nodding their head yes and saying yes. All right, please keep my advisements in mind during the break. They all apply, and I'll see you back here. Let's plan on taking a little bit of a longer break because I need to talk to counsel about scheduling and some administrative matters. So let's plan on taking actually, hold on. Before you do that, would counsel please approach for just a moment? It's 3 o'clock, folks. Let's have you back at 3:35, okay? All right. Thank you. Please be seated, everyone. The record should reflect that the jury has now exited the courtroom. Ms. Brady, is it okay with you if I do the Curtis advisement at this time?
Your Honor, can I make a record really quick before we do that?
Yes.
I just wanted to supplement our victim impact record with statements that Ashley Mosher obviously was crying and upset, and understandably so, but I didn't want to put that on the record. I also wanted to note that we tried to keep track of which jurors were also crying, and we noted jurors in seats number 1, 2, 5, 11, 14, 20, and 21 were crying during that testimony. That's all.
Right. Do the people want to respond?
No, sir, thank you.
I only noticed a couple of folks, and I noticed the people sitting in seats number 20 and 21, I believe they are. I noticed that they were crying, and those are the couple of folks who have cried at different points throughout the victim impact testimony. I think on a few different occasions, or perhaps 4 occasions yesterday and today. One of them is a deliberating juror, the other one is not. I did not notice any of the other ones. That's not to say that they weren't, but I did not notice any of the other ones. I did look in the way of the jury on a few different occasions to see whether they were getting emotional. I did not get the sense that they were getting emotional other than 20 and 21, the people sitting in seats 20 and 21. As I've said before, though, I haven't noticed that the jurors in general have been particularly emotional. For the most part, they haven't been affected by the victim impact evidence. I made a record before, and I stand by that record. There was one time yesterday when there were a handful of them who were crying. It was not excessive crying, it was not bawling, but they were, I noticed them crying. We took a break after that, and right before the break, I gave them the cautionary instruction. At other points, yesterday and today, 3 other occasions, there have been a couple of them that I've noticed crying. That's the people sitting in seats number 20 and 21. Again, the same type of thing. Their eyes get teary. They clearly have tears, but it's not excessive crying or bawling or anything like that. And that has happened about 4 different times, I would say, in addition to the one time that I mentioned earlier about yesterday when there were about 5 of them that I noticed were crying. So overall, I am not concerned that this jury has been overwhelmed with emotion as a result of the victim impact evidence. The testimony has been emotional at times, very emotional at times, but I am comfortable that this jury understands my cautionary instruction that they will follow it. I'm very confident in that. I don't think that they have been particularly emotional throughout. Certainly, I was concerned with that risk before we started, but I've been watching them as much as I can, and I'm not concerned. So, all right, is it a good time, Ms. Brady, for me to do the courteous advisement of your client at this time?
Yes, sir.
All right. Mr. Holmes, I need to speak to you directly at this time. I need to advise you about your right to testify in this phase 3 of the sentencing hearing, as well as your right to not testify in this phase 3 of the sentencing hearing. Can you hear me clearly right now?
Yes.
If at any point there is anything that I say to you that you do not hear clearly or that you do not understand, would you please let me know that?
Yes.
I need to advise you that you have a right to testify in this phase 3 of the sentencing hearing, which is the final phase of the sentencing hearing. This is the last opportunity that you would have to testify in these proceedings, and I'm specifically referring to the sentencing hearing. If you want to testify in phase 3 of the sentencing hearing, no one can prevent you from doing so. You may take the witness stand and testify in phase 3 of the sentencing hearing, even if it is contrary to the advice of your attorneys. If you want to testify, no one can prevent you from doing so. I always tell people who are accused of crimes and who are in trial that it's always a good idea to speak to their attorneys about this, but in the end, this is a decision that they have to make. And I've mentioned that to you before because I've given you this advisement before, but I'm mentioning it to you again. If you want to testify, no one, not even your attorneys, can prevent you from doing so. If you were to testify in phase 3 of the sentencing hearing, then the district attorney would be allowed to cross-examine you. And you have seen how the district attorney's office has cross-examined witnesses who have been called by your attorneys. It would work the same way. The district attorney's office would have an opportunity to cross-examine you if you were to testify. If you've been convicted of any felonies, the district attorney would be entitled to ask you about those convictions and thereby disclose those convictions to the jury. If any felony convictions are disclosed to the jury, I will instruct the jury that it can consider them only as they bear upon the issue of your credibility. I would instruct the jury that it cannot consider those felony convictions for any other purpose. I'm going to ask the prosecutors at this time if they are aware of any felonies of which you have been convicted. And I know that I've done this before, but I want to confirm it. So, Mr. Orme, would you confirm for me that you and your colleagues on the prosecution's table are not aware of any felony convictions for the defendant, Mr. Holmes?
We are aware of no prior felony convictions prior to the ones in this trial.
All right, thank you. And of course, when I talk about prior felony convictions, I'm not referring to anything that's happened in this trial. In this case, jurors are permitted to submit written questions that they would like to have asked of witnesses. The same rules of law, including the same rules of evidence that apply to attorney questions, also apply to juror questions. The court will not permit improper juror questions to be asked of a witness. If you decide to testify in this phase 3 of the sentencing hearing, and if the jury submits one or more questions that the court determines are legally proper to be asked, you will be asked those questions. I've mentioned this before to you. We would follow the same process in terms of juror questions if you decided to testify in this final phase of the sentencing hearing. That is to say, the jury would have an opportunity to submit questions in writing that they would like me to ask of you. I would call the attorneys to the bench. We would discuss any questions submitted by the jury. I would then entertain any objections to those questions. If I sustain an objection based on the rules of evidence and other applicable rules of law, I would not ask you that question or the question that was objected to. If I overruled an objection and found that a question was appropriate based on the rules of evidence and other applicable rules of law, then I would ask you those questions. And you would then be given an opportunity to answer those questions. And I would then give the attorneys an opportunity to ask follow-up questions, starting with your attorneys and following with the prosecution. The follow-up questions would be limited to the scope of the questions asked by the jury. I mentioned to you before that you have a right to testify in this final phase of the sentencing hearing. I need to advise you that you also have a right not to testify in this phase 3, the final phase of the sentencing hearing. You are protected by a constitutional provision against self-incrimination. Therefore, you do not have to testify if you do not wish to do so. If you choose not to testify in phase 3 of the sentencing hearing, then the jury will be instructed about that right and that no inference, no negative inferences can be drawn from the fact that you chose not to testify. In fact, let me tell you the instruction that I would give the jury about this. I would instruct the jury as follows, and I would only do this if your attorneys ask me to do it, and I believe that your attorneys have asked me, in this case based on their tendered instructions, to do it. So given your attorney's request, I would instruct the jury that every person charged with a crime or convicted of murder in the first degree has the constitutional right not to testify. The defendant did not testify during the first trial or in the sentencing hearing, as was his right. You shall not draw any negative inference from his choice as to the punishment to be imposed or any other matter. You shall not allow his choice to prejudice him in any way. His decision not to testify cannot be used as a reason to support or impose the death penalty. You must not discuss the defendant's choice not to testify or permit it to enter into your deliberations in any way. The decision whether, or that's the instruction that I would give. And that I would do that at your attorney's request. If your attorneys requested that I not instruct the jury about that, I would not. But again, I believe based on the tendered instructions your attorneys have provided that they are asking me to instruct the jury along those lines, and so I would read that instruction that I just read to you. The decision of whether or not to testify is a decision that must be made by you and by you alone. It is a personal decision. In this case, you've been advised and represented by Ms. Higgs, Mr. King, Ms. Brady, Ms. Spengler, and Ms. Nelson. Have you discussed with them whether or not you will testify?
Yes.
Have you had enough time to discuss this matter with them?
Yes.
Do you need more time to talk to them about this matter?
No.
Have you made a decision as to whether or not you will testify in phase 3, the final phase of the sentencing hearing?
Yes.
And what is your decision?
I choose not to testify.
Is this a voluntary decision?
Yes.
And is this your personal decision?
Yes.
Is this a decision that was made as a result of pressure?
No.
Is this a decision that you made as a result of influence?
No.
Is this a decision that you made as a result of threats?
No.
Is this a decision that you made as a result of any promises?
No.
Is this a decision that you made as a result of any coercion?
No.
Do you have any questions at all for me about the advisement that I just provided to you?
No.
Do you understand both your right to testify and your right not to testify in phase 3, the final phase of the sentencing hearing?
Yes.
Do the people have a request that I make any further record or that I ask any other questions?
Your Honor, one of the questions you asked was this the result of influence? And I'm not sure if that's supposed to be undue influence or some other type of influence or just influence in general. And I just don't remember, so I thought I would bring that up. I'm not making any request.
Okay. Has anybody in any way influenced you improperly or unduly or unfairly in making your decision?
No.
Is this your own decision, your own personal decision?
Yes.
And you understand that nobody can prevent you from testifying if you want to testify.
Yes.
Not even your attorneys can prevent you from doing that. Do you understand that?
Yes.
And if you choose not to testify, nobody can prevent you from standing by that choice. Do you understand that?
Yes.
All right. Is that sufficient?
Sir.
All right. Any other record that the defense is requesting?
No, sir.
Any other questions that the defense wants me to ask?
No, sir.
All right. Based on my discussion with Mr. Holmes, I find that his decision to not testify in this phase 3, the final phase of the sentencing hearing, has been made knowingly, voluntarily, and intelligently. Ms. Brady, is it okay with you if I now proceed with the advisement related to statement of the right to make a statement of allocution?
Yes.
All right. Mr. Holmes, I need to speak to you directly again. If you do not understand something I say or you do not hear clearly, would you please let me know that?
Yes.
And can you still hear me okay?
Yes.
And are you still understanding me okay?
Yes.
Do you understand that you have the right to allocution?
Yes.
And do you understand what that means?
Yes.
Do you understand that that's different than your right to testify?
Yes.
And have you talked to your attorneys about your right to make a statement in allocution and the difference between a statement in allocution and testifying?
Yes.
Do you have any questions for me about that difference or about your right to make a statement of allocution?
No.
Do you understand that if you make a statement of allocution, you will not be under oath?
Yes.
Do you understand that if you make a statement of allocution, you will not be cross-examined?
Yes.
Do you understand that if you want to make a statement of allocution, no one can prevent you from doing so?
Yes.
That includes your attorneys. Do you understand that?
Yes.
Do you understand that you do not have to make a statement of allocution and no one can require you to make a statement of allocution?
Yes.
Do you understand that if you decide not to make a statement of allocution, the jury will not be advised in any way that you have decided not to make a statement of allocution to them?
Yes.
Have you consulted with your attorneys concerning this issue?
Yes.
Are you satisfied with the advice that your attorneys have provided concerning this particular issue?
Yes.
And do you understand your right to make a statement of allocution?
Yes.
Do you also understand your right to not make a statement of allocution?
Yes.
Do you desire more time to discuss this issue with your attorneys?
No.
Whether or not you give a statement of allocution is your personal choice. Although you may have consulted with your attorneys and they may have given you advice on this issue, do you understand that whether or not you give a statement of allocution is your choice and not your attorney's choice?
Yes.
Whatever your decision is it your free and voluntary choice and your own personal decision?
Yes.
Do you have any questions of the court before I ask you for your decision?
No.
Do you need more time to think about this or to consult with your attorneys about your right to make a statement of allocution and your right to not make a statement of allocution?
No.
And have you made a decision?
Yes.
What is your decision in terms of whether you will make a statement of allocution or whether you will not make a statement of allocution?
I will not make a statement about it.
Any additional record at this time from the people?
No, Your Honor, thank you.
Any additional record or any additional questions that the defense is requesting?
No, thank you.
All right, based on my discussion with Mr. Holmes, I find that his decision to not make a statement of allocution is one that has been made knowingly, voluntarily, and intelligently. All right, what I propose is that we take a break, about a 15-minute break. Then I'm going to bring the jury in. I'm going to ask the people to call their next witness. It's my understanding that the prosecution will rest at that point. I'm going to ask the defense if they wish to present any evidence, and it's my understanding that the defense will rest at that time. And then I'm going to give the jury the advisement, send them home, and have them come back tomorrow at some point for closing arguments. The question is, when should we have them come back? We can work on instructions today, but that depends on how late you can stay. My preference would be to get as much work done on the instructions as possible tonight or today, and then try to finalize them tomorrow morning. So that's the first question. The second question has to do with any objections related to PowerPoint presentations. Are there any, and how much time should I set aside for that?
Your Honor, I'll speak to the PowerPoint part of this thing. I spoke with Miss Brady, and if I'm speaking out of school, ma'am, correct me. She's indicated she's not going to have a PowerPoint. Mine would be limited at this point to photographs that have been previously admitted and used in other portions, nothing with words, nothing from the notebook or any of those other privileged communication areas that we've previously discussed. So I don't think the court needs to set aside a significant amount of time as it has in the past to review these.
Okay, great. I don't know how lengthy our instructions conference is going to be, so to play it on the safe side, what I would suggest is that we start at 1. How does that sound? If we have the jury come back at 1 tomorrow afternoon, it's going to take me about an hour to read the instructions, and or maybe a little less than that. Then we'll have to take a break, and then the attorneys can go into their closing arguments at that point. If we have any time, the jury can start deliberating. Otherwise, they can come back and start deliberating on Friday morning. Does that sound reasonable?
Yes, sir.
It does. And I assume I'll get to see the pictures Mr. Brockler intends to use.
Okay.
Okay. Thank
All right,
you.
Please. Okay, is there anything else then before I step down for the break? Anything on behalf of the people?
No, sir.
Anything on behalf of the defense?
I think Ms. Nelson is standing.
I just wanted to let the court know I would need another break before we begin discussing instructions, but it's also my preference to do as much as possible tonight. I'm available to stay as late as the court desires. So.
Okay. All right, let me check with all my staff and let me check with my court reporter as well to see how late we can stay. I emailed the parties a second set of instructions which would apply in the event that the defendant chose not to make a statement of allocution, which he now has chosen not to make a statement of allocution. So we will go with the second set of instructions. So these are modified. These are different than the first set I had set. And I think we'll refer to this as the second draft. And the draft that's stated today August 5th of 2015. That's a draft that we will be working with, not the draft that I had emailed you a couple of days ago. Okay? All right, the court will be in recess.